All right, let's look into B, international custom. Okay, international custom, all right. See, as evidence of a general practice accepted by law. We are now in the second part, yeah? All right, B. We are looking into the explanation, all right, Article 38, Clause 1B. Right, okay. Now, what we are doing at this part, we are looking into, all right, as much as we can, all four, including subsection 2 first. And then next week, we are going to go into one by one because it's a long and lengthy hours needed for international convention and customary, international custom. Okay, today we identified it, international custom. Right, this international custom is referred to in two words, right, in two conditions, two parts explanation that you need to read and understand. The word appear on this section 38 clause 1b is international custom, but the discussion in the book always refer to custom to be terms as two. Satu, customary international law. Dua, international customary law. Right? Okay. Now, why do they have two terminology? It's because the part of common law call it customary international law. The one in the contemporary, like US, call it all right, international customary law. We in the common law side, we call it customary international law. So if you read a book, that book refers to CIL, all in capital, all right, then you know it's a book from the perspective of positive law, common law. Tapi kalau you nampak dia panggil international custom, international customary law, international custom, but the discussion is in international customary law, ICL, then you know it's from the side of positive law, which is contemporary law and American and sometimes France, right? Okay, so then why are these books important? Right, they are important because you want to defend your position by referring to the custom. Right, some of the authors who write the book, their book can be an evidence that the law have been practiced before, so that law can be now a source to help you solve the dispute when you are in court. Right, okay, when you are in court, right, in ICJ court, part of your job, a big part of your job is preparing for the documents, right? Although when you speak, all right, you are not referring to that substance, but the substance has to be perfect. Jadi, even though in the ICJ, when they solve dispute, they have a different methods from our court, all right? Their court is not adversary. Their court is inquisitory. Our court is adversary, meaning that how clever you are, it's all here in your head, all right? Unless you have to submit your cases, all right, which sometimes judges doesn't demand. So all the beauty of your thoughts is protruding in your mouth, right? You can be you, right, with a little notes in your hand and then argue for the case. That's adversary. But when it comes to inquisitory, all right, it doesn't happen that way. Although they appear in court, right, when they appear in court, it's very, very rare that they get to be objected. When they appear in court, they are only summarizing the whole bundle of documents that they have already submitted. So the system is different. Maybe one day, as a law student, you'll be able to have this training. In order to get the training, you gotta go to the Institute of the Hague, all right, through your office, which is government, all right, okay, that's a course one day, all right, that you people would want to go. But at this moment, to solve dispute, international custom, okay, right, you have two types, customary international law and international customary law. I presume they are the same. So from time to time, I refer to you as customary international law. Terminology saja different. All right. Now let's look into this custom. Customary international law, in order for it, ni perkataan dia, must be evidence of a general practice. All right, there are some rulings over here. All right, international custom, evidence of a general practice accepted as law. Those are the elements that you need to read and classify and clarify and explain every time when you understand the word international custom. All right. Okay. Now, to become an evidence, right, it has to be that customary practice, right, must be practiced by the state, not practiced by the people. Right. The evidence, in order for it to be established, what it customary international law to be established, it must be, all right, okay, a customary law, customary practice by the state. Or in another word, it must be a state practice. Right? Okay, perkataan state practice, that's the first one. All right, now, whose practice is state practice? Government practice. Now, who is government? All right, this is more complicated, right? Some government are just one single government. Some government are the monarchy. Some government are parties, right? Some government have senate, and then they want rakyat, they want negara, and some government has cabinet. All right. Okay, so you see, as long as it is the government representing the state at that particular time, and that is the state practice, right? Okay, either they produce the law as law, legislation, all right, or they produce a policy that is sanctioned by the Senate or by the cabinet, all right? Macam mana cabinet punya policy? They have agreed. The winning party who sits in the cabinet have agreed. They had a policy. That policy is customary practice because it has become a regulation in the Director General's procedure later for the public to adhere to it or the enforcement to practice it. All right. Okay. Sometimes, all right, the practice of a state become law. It goes to the parliament. In the procedure, they want rakyat, they want negara, all right, released by the, or in some situation signed by the Agung. Right? Okay, so you see, it has to be a state practiced. It has to be custom practiced by the state. It has to be state custom, state practice. State. All right. Okay, so dalam problems in exam, all right, it's always the state too. They are going to highlight you, give you a clue that probably, the majority didn't undi, only 1% and the rest didn't agree, something like that. They will give you a problem with regards to customary practice must be from the state practice. All right. Okay, now coming back, I'll give you an example. That state practice that has become evidence of law and it has been accepted. All right. I'll give you an example of international custom. They become mula your state party, lepas tu they become international custom because the rest of the world accepted it, not objected to it. Right? I'll give you an example that two examples where it becomes this practice of the states become, all right, international custom. Number one, all right, visa. All right, visa. Tahu visa? When you want to go to America, you have to have a visa. Now you want to go to England, you have to have a visa. You want to go to Australia, you have to have a visa. All right? Okay, this visa is actually firstly introduced by America. Right? Okay, they introduced it, all right, and they say for all foreigners to come into America, they will need a visa, a permission to apply, and then be granted the visa, pay some fees, all right, and then they give a stamp on your passport, then you can enter, all right, besides the fact that you are legal, all right. Okay, therefore, that visa, first introduced by America, later the rest of the world follows. You see, state practice, custom state practice. State practice that in America and the rest of the world follow. Itu baru rules number one. Okay, that it must be a state practice. Another example of customary international custom that the whole world have applied, all right, without questioning it, kita do the same like the rest of them did, was stamp. Customary practice 10. England introduced that to send a stamp, to send a letter from one country to another country, all right, to represent that the original of the letter come from one country, all right, okay, and must be respected by all the country that it is walking through, all right, so it bears a stamp. A stamp is just small thing, maybe today you have never licked a stamp, all right, or seen a stamp. Okay, it's just a stamp. You buy that stamp in the post office, all right, it carries with it an emblems of the state. For the England, they had a queen head or whoever that they commissioned. In Malaysia, they have flowers, sometimes they have these torties, all right, okay, sometimes they have a head of the king, a picture of the king, all right, or prime minister, whichever that the country wanted to commission. But anyway, if you're sending by the snail mail, you need a stamp, put it on an envelope, and then send it over, all right, to the post. All right, I don't know how effective in the post now with a stamp. I know a post office is effective in delivering goods, but I don't know about the stamp. About Kad Hari Raya, for example, people don't send that in physical anymore. All right, okay. All right, having said that, that is the two examples. Okay, customary practice. There are also customary practice that affected the country position. All right, that affected the international that brings in international dispute from one country to another country. That brings you to the case of, all right, asylum seekers. All right, asylum seekers. Apa nama case dia? Asylum seekers. This is a case that brings you to the name of the case apa tadi? Asylum case, or sometimes they go around by the word asylum seekers. Some books tulis dia asylum seekers, tapi you can Google this case for the summary as asylum. All right, this case asylum, all right, is about what? Is about one state customary practice, following the rest of the world customary practice is objected by the other states. So they go to PCIJ to have the case, to have the dispute, all right, entertained or discussed. All right, apa macam mana case dia between these two countries. All right. It is between a country. Anyone knows the facts so that you don't have to wait for me? Asylum case. This is the case between Colombia versus Peru. All right, I have given you a list of case. Look into that list for the citation. All right, okay, so in the case of Colombia versus Peru, what are we looking for in this case at this stage? We are looking into how international custom that is available being followed by one country which have never followed it before, tapi, all right, the act of following that is objected by another. All right, so the issue here is, all right, can the state, all right, can the state of Colombia, the Colombia is the state that this fella, let me just go into the facts, that the guy is called Haya de la Torre. Right, nama dia panjang. Nama dia Victoria Rahul Lahaya de la Torre. Alright, selalu kita remembered it by the word Haya de la Torre. Haya de la Torre is actually, alright, okay, he is a Peru national. Dia rakyat Peru. He is a Peruvian national, alright. He seeks asylum in the country of Colombia embassy, alright. He seeks asylum in the country of Colombia. All right. Okay. Now the thing is this: when he seeks asylum in Colombia, Peru objected. All right. Okay. The facts of the case show that Haya de la Torre is actually a reporter. When he was reporting on the condition between the two countries, all right, there was a warrant of arrest for him to be arrested. All right. Okay. Now, instead, before they could catch him, all right, he have already smuggled himself into Colombia and seek asylum over there. Colombia country gave him asylum. All right. So, bila Colombia gave him asylum status, right? Peru objected by saying this, that Colombia have never practiced asylum before. So, therefore, asylum is not available to Colombia, right? So, they both go to ICJ to have the status, all right, the status in dispute clarified. The court says that, right, giving asylum seekers, giving asylum standard to the seekers, all right, okay, is actually an international custom. All right, many countries have done that. They becomes international custom. So this international custom, all right, has no limit whether your country have applied it before or not. So if this is your first time applying that law, then you can do so. That's the decision in the case of asylum seekers, Colombia versus Peru, with regards to the status of Haya de la Torre. So the position of Haya de la Torre in the country of Colombia is considered as legitimate. The status given by Colombia to Haya de la Torre is also considered as valid. Therefore, he cannot be sent back to Peru for the trial of him being a rebellious in his report, all right, towards the country Peru. Boleh? So that is condition number one. It is a state practice, right? It is a state practice that has become international custom. So once it becomes an international custom, any country who have never practiced it before can practice it anytime. All right, it's available for the state to take. All right, okay, that is on the evidence of a general practice, evidence, state practice. Now, the next ruling on the state practice is rules number 2, that state practice must not ever be objected by any country, right? Rules number 1, it is a state practice. Rules number 2, that state practice must not be objected by any country, all right? So once it is objected, it cannot become a state practice. It cannot become international custom. All right, okay. Now, example to that one is in the case of declaration, request for declaration, allocation declaration here to ask for permission United Nations to grant preemptive strikes, right? Okay, in the facts of the case is like this. All right, Prime Minister Hope from Australia requested, all right, for the states, for the whole states members in General Assembly, United Nations meetings, all right, General Assembly meeting, the request for a voting of agreement, or to agree on his proposal. He said, all right, the whole world should be allowed to give preemptive strikes. All right, so kalau the whole world agree, then it becomes a state practice that is allowed, sanctioned by United Nations, and now we can have a preemptive strikes. All right, now full stop a minute. What is preemptive strikes? Preemptive strikes is actually the action of engaging into war, all right, or insurgency or a defense, engaging into war using weapons for a defense against a suspected location. Right? Katalah, all right, they suspect there are a terrorist in Afghanistan, all right, in a town called Rarani, for example, all right. Okay, in that town, through their surveillance, they suspected a group of people meet, there are sort of heat, there are weapons, they can tell that through the radar surveillance, all right, there are all men, all right, they've been meeting there often, all right, so they suspected that a group of this Afghanistan in that town, all right, is a terrorist group planning something. So from Australia, they can carry out, all right, a preemptive strikes and bomb that area. Okay, right. Those are the proposals, right, in the United Nations summit at one time, right? So if this proposal is agreed by all members, right, it will become international custom straight away. But that proposal was objected by Tun Mahathir then, right? Okay, and when he objected it, he was supported by his gang of the South nation, consist of 77 countries. So it's a big vote to object. Therefore, today, preemptive strikes is not allowed. Right? Okay, so you see, that is said. Number 2, rules number 2, if, all right, international, if state practice, all right, it's objected, then it will not become international custom. So in the law of war, you cannot have preemptive strikes. You have to be strike first, and then you defend yourself through self-defense. That is allowed. But if you suspected, all right, a country or a place, all right, in the nature of preemptive strikes, you want to take action before it happens, right, that one is not allowed. Yeah, all right, that's an example. Number 3.
Madam,
Yes,
Madam, I have a question.
Okay, go on. Yeah.
In that case, I'm just curious why we cannot follow majority opinion instead of we must have all the state to agree to the proposal image.
Yeah, because it's just a proposal.
Oh, alright, Madam.
Yeah, proposal must be sanctioned. Jadi, when the proposal is being killed by an objection, then it cannot become a resolution. Tu kalau dekat United Nations punya ruling. Boleh, Alisa?
Oh, Madam, does it mean that if resolution stays, so the decision tu it must be majority lah?
Macam ni. Ya, betul. Dia nanti ada ruling dia. This is the part that you will learn in your 583 United Nations voting. Right, resolution. For the resolution to be law, it has to be 2/3 majority of those people present. Right? Sometimes when people hate a resolution being read, like this one, everybody stays. But then because nobody, not enough number that agrees, and when it was already a proposal, it has been killed. Right? So once a proposal have been killed, it cannot become a state practice and it cannot become what they call as customary practice, international customary practice. Tapi coming back into tadi my example, what I wanted to say is, in the United Nations, in order for it to become a state practice through United Nations summit, United Nations General Assembly, or in short, summit. All right, you can make law through that. All right, in 1955, in 1951, United Nations have a declaration of friendly nation. Bob Hawke, the Prime Minister of Australia, wanted to repeat the experience of making international custom through United Nations General Assembly summit. Tapi it fails. In the 1951, all right, England made a proposal, all right, that the whole world in 1951, right, that is after the war, must give agreement. Ini proposal juga, all right, that we all reject communist. ideology. It doesn't matter whether it is a communist, as long as it is in a sense of communist, the one that they hated in the Cold War, all right, they cannot become a party, a winning party to the state. All right, okay. Now, having said that, that doesn't include China. All right, China is not a winning party. China is a party. All right, dia tak ada siapa-siapa parti kat dia, dia satu saja. All right, okay. Now coming back into my example, all right. So everybody agrees on that particular day, all right, to the proposal and then vote to the resolution. The resolution become a declaration and it becomes war. Itu yang you nak belajar dekat D nanti. All right. Custom, international custom ni, either the states make it or sometimes it can go into through the United Nations General Assembly. Bila General Assembly kata, all right, do it, and then it becomes a state practice. A state practice, sometimes you do it, sometimes like open burning, remember open burning? All states have already adopted Stockholm Declaration. So that one is actually not created by one state. It's only a proposal in the United Nations. All right. Tapi it can become an evidence of a general practice accepted by law. So today we see Stockholm Declaration not open burning in our Quality Environmental Act. Macam tu, ya. Alright.